First order of business is roll call.
Priya Mather,
Good afternoon.
Dana Hollinger,
Good afternoon.
Margaret Brown,
Here.
Steve Juarez for John Chung,
Here.
Rob Beckner, Ramon Rubalcava, Teresa Taylor.
We have a quorum. Please also note for the record that we have Mr. Miller, Mr. Jones, Mr. LaFaso, Mr. Gillahan, and Mr. Costigan in attendance today. And Mr. Slayton, all the way at the other side. The next item on the agenda is the approval of the Board Governance Committee timed agenda.
Move approval?
Moved by Ms. Brown.
Second.
Seconded by Ms. Hollinger. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes. That brings us to the executive report. Mr. Jacobs.
Yes, good afternoon, Chair Mather and board members. We have one substantive item on the agenda today. It's the process for handling allegations against board members. There was one other substantive item that was supposed to be on the agenda, but that's the board self-evaluation process and update, but that has been deferred. But I can assure you that Ann Simpson is working hard on that and related topics. So that is my report.
Thank you. I would also just note that the other item that we're still in process on is the closed session other confidential materials review process, and that we're going to fold into a broader data security, data protection policy. So that's currently under development at the moment.
Right. Good.
Okay, terrific. That brings us to the action consent items, approval of the May 14th, 2018 Board Governance Committee meeting minutes. What's the pleasure of the committee? Motion's made by Taylor.
Second.
Seconded by Hollinger. All those in, any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes. And that brings us to the information consent items. I've had no request to pull anything off consent. Agenda item number 6, action agenda items, process for handling harassment allegations against board members. Mr. Jacobs.
Yes, very good. So this emanated from a request by the committee to bring forward, or actually to begin with, to look at what other agencies have done with respect to policies on handling allegations of sexual and other types of misconduct. We did some research on that, brought back the only one that we could find, which was the UC Regents policy that was adopted last year, I believe March of 2017. And we had a discussion about that at the last Governance Committee meeting. This committee was generally in favor of it and directed us to go back and kind of make it applicable to this entity, CalPERS, which we have done. And essentially what we did is strip down the parts that we saw as superfluous, strip down the parts that don't apply, made a couple of changes to make sure that it was applicable to CalPERS, took out the part that made it generally applicable to any kind of misconduct that occurred, whether or not it pertained to the agency's business, and have brought it forward in attachment 1 to the agenda item. We think it's pretty clean, and happy to entertain any discussion or comments, questions about it.
Thank you, Mr. Jacobs. What is the pleasure of the committee on this? Motion made by Ms. Taylor. Is there a second to the motion?
Second.
Seconded by Ms. Hollinger. On the motion, Mr. Costigan.
I just had a question on the policy, Mr. Jacobs. On the confidentiality aspect of it, and what I don't see in the Regents policy or in ours, can that be waived by either party? Because similar to peace officers, it's up to the peace officer in a personnel matter to make a determination whether they want it waived or not. So you start with the presumption that the matter is closed, the proceedings are closed.
Right.
But in the event of the board member, does this policy prohibit or prevent it from being disclosed? And the caveat again, if it's related to a closed session item, you can't talk
Right,
about the closed session
right.
item.
I would say in the normal course, and if it's not in that type of circumstance, that yes, the board member could waive it.
Okay, thank you. Thank you, Madam President.
Thank you, and that doesn't need to be explicitly spelled out in the policy.
No.
Okay. I think there was a question raised as to whether the composition of the panel that would review the matter should be dictated here, or whether just the process for determining that panel should be dictated here. So whether it should be the board president would assign a 2-member panel, or whether it should be very prescriptive. And I think it might give us more flexibility in the event that, let's say, the vice president's not available, if it's a little more general in that regard, that the board president will determine the composition of the panel.
We could certainly make that change. It's,
If that would be,
I understand the point.
if that would be amenable to the maker and seconder of the motion.
Yeah,
Okay.
that's fine with me.
Thank you. Mr. Slayton.
Thank you, Madam Chair. Matt, I wanted to ask you about, in Section 4, type of sanctions, and number 4 in particular. So do we, because we've had this come up in other issues in the past, does the board have the power to recuse a board member from participating in an activity of this board or a committee? So,
I believe it does.
okay.
There would have to be a pretty close nexus between the type of activity for which the board member has been found to have engaged in misconduct and the particular matter which he or she is being, or is up before the committee or board. So you couldn't have somebody who's found to have made a harassing comment be prevented from participating in an investment committee decision, perhaps on an investment, but if there's a pretty close nexus, and it's going to really depend upon the facts and circumstances, but you could. That's our best reading of the law.
Okay. So what I hear you saying is that we may in the future have other things. This is dealing strictly with harassment. We might have other situations where we want to create something similar to this. And again, if that nexus is close, then your reading of the law is this board does have the authority to recuse a board member from participating.
Yes.
Okay. Thank you very much.
Thank you. Ms. Brown.
Yes, my question goes to, again, item 4 on page 4.4, which is types of sanctions. So it talks about revocation of board member privileges. So what's a board member privilege? Because they're not identified here, and they're not identified anywhere in our policies or procedures. So can you give me some examples of a privilege?
Well, I would say travel is a privilege, attendance at educational programs.
Oh, education is a privilege? It's required.
Okay, well.
Education is required under the board policy.
Right, but there are different types of educational opportunities, some of which require travel or more expense than others. We often provide quite a bit of education in-house, if you will. So education per se is not a privilege, but types of educational opportunities would be a privilege. What else?
So would you say that travel to meet with constituent groups would be a privilege that would be denied an elected member?
Probably not.
So I'm concerned that there's not a clear definition of what is or is not included. And I would really hate to leave it to board members who maybe I'm out of favor with, who could be deciding this policy for me or another board member. So my suggestion is that we clean this up in terms of what those actual punishments could be, so I don't actually find myself or another board member find themselves on the short end here. And then the other question I have is with respect to having in-house counsel do the investigation versus independent counsel do the investigation for the exact same reason.
Okay, thank you. Ms. Hollinger?
Yeah. My question is this, and maybe you'll have to get back to me, maybe not. In the event of a harassment or certain violations, is that covered under our DNO, or because I know sometimes certain insurance coverage doesn't cover, maybe they'll cover negligent acts, but not necessarily intentional acts.
Yeah.
So,
I will have to beg off on that one and get back to you.
okay, yeah, because I also think it'd be worthwhile to know if there's potential personal liability.
Personal liability for what? For the action that
Well,
would be
I
under
guess in
investigation?
terms of us having to defend ourselves, like whether it would be covered under our DNO policy or not.
Right, but are you talking about defending yourself against an allegation of misconduct, or defending, for example, the committee or the board against the investigative process?
No, just potential misconduct.
Oh, okay.
Thank you. Mr. Gillihan?
Thank you, Madam Chair. The second point Ms. Brown was making, I think it warrants some thought here, and that is, if an investigation can be done by an internal CalPERS staff, that's probably going to put that staff person in a potentially awkward situation. And I know within the administration, when allegations are brought against higher level staff, and this is true at CalHR as well, we often use the Attorney General's office to conduct those sort of more sensitive investigations. And I would just offer that I think that's a more perhaps objective and more appropriate entity to conduct investigations of board members as opposed to internal staff. Thank you.
Is that a motion to amend? Or? Oh, you're not on the committee, of course. Okay. Thank you for your thoughts, Ms. Taylor.
So I will make a motion to amend, but first, I want to make sure that before I do so, hold on one second. I'm wondering if we should, for the first thing Ms. Brown said, which is specify what we are saying that is board privileges. Before we go through with this, I don't know if we, because it's very nebulous right now, so I'm wondering if maybe we could put a list of things together before we, or say that we will upon rewrite. We can vote on, I don't know what you want to do.
So the board governance policy, and I'm sorry, I don't have it up in front of me, does list a few things, and it says including but not limited to. Perhaps we could just copy that language into here.
Sure.
But
That's a good
I think
suggestion.
the types of privileges, it might be somewhat fluid. It might something might come up that is not currently current practice, but in the future there might be something that we would wish to include. So I'm not sure that we want
So
to be
we can say
completely
board
prescriptive about
privileges
it.
inclusive of,
Yeah, including but not limited to.
not
perhaps.
limited to, if we could say that.
Sure.
And then I would make a motion to amend to include that as rewritten, as well as an outside independent counsel.
Can I make a suggestion on that?
Yes.
The section B, this is 3B on page 2, talks about and distinguishes between a preliminary investigation and a formal investigation, and it says that upon determining that a formal investigation is warranted, the general counsel shall, with the concurrence of the reviewed panel, appoint an investigator who may or may not be a CalPERS employee. I'm personally completely happy with outsourcing this, but I'm also concerned about the cost to the agency of doing that when, if you if you farm it out, you can end up spending a lot of money because somebody takes it over. I mean, you've seen some of these special counsels on a national level just kind of spend millions of dollars. I'm not suggesting anything on that scale, but you, at least for the purposes of the preliminary investigation, there is some value in maintaining that within CalPERS, not necessarily the Office of the General Counsel, but within CalPERS. And then as I read this, the way it reads to me is that at that point, if the GC, with the concurrence, of course, of the review panel, think that a formal investigation is warranted, they can assign it to an investigator. And I think that's the point at which the determination that Mr. Gillihan was making can be made about, again, with the concurrence, who ought to be doing this. And I know that I personally, and most GCs, and I think the board members are going to have the sensitivity to know when that ought to be farmed out and when it can be effectively done in-house. So I throw that out there as one possible reason why this thing, this draft is good as it is. But I'm agnostic. I just wanted to point out that those factors.
Thank you. Ms. Taylor, did you?
Let me read it just really quickly before. So you're saying under the formal investigation portion, which is B, is where we can possibly have that outside investigator or the Attorney General's office?
Right. Right. So the idea would be preliminary investigation comes in.
No, appoint an investigator.
The GC
Okay, yeah, I see it.
and the review panel takes a look at it. Is there any potential here, or is it just outright frivolous? In which case, we're going to just end it. If it's more significant than that, there's something that needs to be looked at here. The GC and the review panel says, okay, part of the inquiry at that point is who should do it? Who should the investigator be? We could make that more explicit in the language.
I think we should still make that more explicit, that it shouldn't be, I will say, working at a state agency, the state agency themselves isn't always non-invested.
Sure.
So let's.
Well, let me do this. Let me play with that language, make with the other suggestions that have come forward, and I'll bring it back at the next meeting, and you guys can take another look at it.
Why don't we bring it back at the next board, just at the board
Sure.
meeting? We don't necessarily need to bring it back to the governance committee, I think, and since that next
Right.
committee meeting could be quite a
It
number
is
of months
several months
out.
off, so yeah, we'll bring it back next month with
do that.
some tweaks and, yeah,
Good.
put it on the regular
Okay.
board agenda.
Okay.
So I
Terrific. Yes,
withdraw my motion.
please. You withdraw your motion. Okay, thank you, Ms. Taylor. Mr. Jones?
Yeah, thank you, Madam Chair. My question was answered on B of Mrs. Brown's concern about the investigation. And on the other item, I think that my question was answered also about you're going to bring back some language that's reflective in our current policy. And then the third thing on that is that even though you say including but not limited to, there may be situations where it falls outside of the realm of both of those. And in that event, the committee or the board will always have the option of adding or modifying the
Exactly.
policy.
It's our
So we can
policy.
include it in the next round. So I think that's a good suggestion made by Ms. Brown also.
Thank you. Mr. Costigan?
So just a couple points. I think first one, what Ms. Hollinger was raising is once there has been a finding and once the board has taken action against that member, one of the 13 trustees, if there is in fact a civil matter pursued by the individual that was harassed, does our insurance cover that? And that's just something, Mrs. Rapini, I think that's what we were talking about is once we've made that finding, do we as the board, we're relieved of our obligation of having to defend pursuit on it. The other is the CalHR director and I were having a sidebar discussion. As it relates to agency secretaries and department directors, the wheel off is to the Attorney General, not for the rank and file. The question you may want to enter into, not just the Attorney General, is actually contracting with CalHR, with the exception if it's the SPB or the CalHR member that's accused, for the rest of the board members, because they have counsel that are available as a way to control costs. And then you enter into an agreement where there's already a statutory, or there's already a rate involved. But I think this is a good discussion to have, but we were just clarifying that for department directors, agency secretaries, and governor's office, if the accusation is against one of those, that's why it goes to the AG, because the question, if it's just a standard and there's no standard sexual harassment, but if there's in fact an allegation filed, it goes through the normal process of the department and agency where there's a finding, where the in-house folks, the EEO officer or someone else typically does the finding on it, and then the process works its way up through the merit system. We as appointees don't have that same protection, and that's, I think, whether it's the AG, but I do think first look at CalHR, and then there's always the carve-out. So thank you, Madam President.
Thank you, Mr. Costigan. Ms. Brown.
Thank you. Since we are going to bring this back after modifications, I'd hope under type of sanctions, maybe you could look at adding a statement that says that no sanction shall interfere with the member's ability to fulfill their fiduciary duties or legal obligation to perform their duties, something like that, so you're not getting into listing specific, but something that says that no matter what happens, you would still be able to fulfill your fiduciary duties, which would get you to training for the educational purposes or a meeting with constituents, things like that.
Interesting idea.
But not a good one?
Interesting can be good.
Thank you.
Thank you. Mr. Juarez.
Yeah, thank you. I would, first, to the point that was being raised, I think that I heard a number of people say, I think the language as it relates to the formal investigation, it shouldn't be open to another CalPERS employee, and maybe that's where you're going to go with this. But I think the sentiment, at least that I share with the people that I heard speak, is that it should always be an outside. We're going to do a formal investigation of a board member. It should be an outside party doing the formal investigation. Certainly leave it to you to do the preliminary one, but not even make it an option for a CalPERS employee to be the investigator. I think that's what I'm hearing, but if not, and when you bring it back, we'll see. And then to the point being made by Ms. Brown, I think you're going to find some difficulty, because if one of the sanctions or options is to remove somebody from committee activity, that could be construed as to impairing their ability to carry out their fiduciary duties. And so I just think giving some protection against that's going to be very tough if, in fact, you can be removed from a committee. And so I would just be cautious and tread lightly on that point if you're going to try to come up with a statement that tries to protect someone in meeting their duties, and yet we're bringing sanctions that clearly will impair that ability.
Although if someone's removed from a committee, they still have the opportunity to vote as a board member.
Voting, but even, I think participation is generally construed to be part of that activity, and if you're not able to participate in the board discussion, I would argue, I think your fiduciary duties are somewhat constrained, so I would just be very careful.
I understand what you're saying, Mr. Waters. It makes a lot of sense. I would just point out the board president can remove a board member from a committee at virtually any time. And that's not assumed to interfere with the committee members or the board members' fiduciary duties.
Well, until it's challenged, until that board member feels that, in fact, their ability is impaired. I mean, I'm not disputing the fact that the president can remove a member from a committee, but if that board member feels that it's unjust in terms of them carrying out their duties, I would say that could be a subject of a lawsuit.
But no board member sits on every committee. So in any case, we can continue having this debate. But Mr. Jones.
Yeah, thank you, Madam Chair. My question goes back to the investigation. Do you have a spring-fed pool of attorneys that covers everything? Is that right? That you can go to on a moment's notice and identify them to conduct an investigation?
It's not quite that broad, but we do have a pool for these types of investigations. We also try to engage the Attorney General's office whenever that's possible and appropriate, and the AG doesn't have a conflict But the short answer is yes.
And do they also include their billable hour rate?
Yes.
They do. So we would know right off the bat what the cost would be to make a quick decision.
Right. Well, we would know what their hourly rate is. You
Yeah.
never know where it takes us.
Right,
but-
exactly.
Right.
Okay, thank
Yes.
you.
Thank you. We do have several members of the public who wish to speak on this item. I will call you up in twos, and you can take these 2 seats to my left. You will have 4 minutes with which to speak. Mr. Behrens, Mr. Jelinek, you are the first 2.
Madam Chair, members of the committee, Tim Behrens, President of the California State Retirees. I'm sorry I missed this morning's meeting where you passed a motion to give merit awards for less than marital. Anyway, this afternoon I'm also disappointed in what I've heard so far. I'm glad and in agreement with your zero tolerance for sexual harassment and harassment. But this seems like an ill-conceived document. I see no due process in there for the accused, which if you read the headlines in Sacramento, you see that happens fairly often. So I would urge this committee to put more thought into this language. I did not see, I have a problem with the formal investigation part of it. I think I agree with Mr. Juarez. I think it should always be a third party. It should be somebody unrelated to CalPERS staff or the board. It should be a third party. And I also agree with Ms. Hollinger. What's the liability for CalPERS? You know, do we have insurance? Do you have insurance that would protect you from a lawsuit when one person accuses another person of sexual harassment and they sue you for that? Those are the kind of questions I hope you will ask yourselves. I think it should always be an outside investigator, and I thank you for your time.
Thank you very much. Mr. Jelinek.
J.J. Jelinek, member, and thank you for the extra minute.
You're welcome.
This strikes me as the perfect Mather-Jacobs policy. Does anyone really believe that Ms. Mather or Ms. Brown will be treated equally under this policy? I know what the public answer is, but I ask you to look into your heart of hearts. This policy purports to enforce the CalPERS Harassment, Discrimination, and Retaliation Prevention Policy. I've been around 30 years. I've seen policies dealing with all of those subjects, but I do not remember ever seeing anything called the CalPERS Harassment, Discrimination, and Retaliation Prevention Policy. I'm very bothered by the fact that a board member may not have the right to a public statement of the charges and a public hearing. What will happen is there will be a public finding that the member somehow violated this non-existent policy and that the following discipline has been imposed. The board member is left to deny that they are not guilty of this unspecified charge. I'm very sensitive to this because of my own experience. Bill Slayton publicly accused me of leaking confidential information, but refused to disclose what I supposedly disclosed. Matt Jacobs made up the charges. I believe that in order to protect his own incompetence or complicity, he asserted that the charges were secret and attorney-client privileged. The board's fiduciary counsel said that the privilege belonged to the board. However, board members who asked were denied access to the charges. The charges were so secret that the client couldn't even see the attorney-client privilege document. Why is this dangerous? Let me make up an example, and I won't violate the attorney-client privilege by talking about the specific charge. But let's say the Sacramento Bee wrote about an investigation in January of 2012. In May of 2015, a board member mentioned the investigation. A board member could be accused and found guilty of discussing confidential information, but prevented from ever disclosing the accusation or showing that it was false or that the information was public and not confidential. Members of the board, especially elected members, deserve a fair and public hearing and defense. Removal from a committee or blocking participation in board meetings may be more punishment for the CalPERS members and constituents than the actual public official, although it may make for a more efficient railroad and lead to shorter meetings. I would encourage greater specificity about the privileges that could be forfeited. Does that include the catered meals behind the stage? Ringing the bell at the London Stock Exchange? Meeting with members? Although Chief Counsel has opined that that doesn't cover. Travel to training seems to be in doubt. I guess it will depend on who's being published. I urge you to just reject this policy. Thank you.
Thank you. The next two who I would invite down to speak are, Ms. Taylor, did you want to say something at this time? Okay. Are Mr. Darby and Ms. Snodgrass. If you could please take one of these two seats to my left. You'll have 4 minutes with which to speak. Please identify yourself and your affiliation for the record.
Do you want to go first?
Go ahead.
Good afternoon. Donna Snodgrass, Retired Public Employees Association. As an EEO investigator for the state of California, I know that if discipline is decided to be meted out to anyone because of a charge, the case then becomes public. So documents the secrecy is done at that point. This policy concerns me because of that. Plus, it's specifically written in the language to avoid the Bagley-Keene Act. Now, you can have a panel to review and determine to investigate without divulging personal information in the beginning. I feel this is one more way to remove transparency of the actions of this board. In the case of the elected seats, if someone gets accused, constituents need to know more than just, oh, David Miller's on punishment and has been removed from a committee. Sorry, David. We need to know, should we re-elect this person or not? And plus, in my view, anybody who's been accused has a right to due process and should be able to face their accuser. Thank you.
Thank you. Mr. Darby.
Committee Chair, committee members, Al Darby, President, Retired Public Employees Association. The issue I want to bring up, the other speakers have already mentioned most of the other issues that need to be addressed, but the issue I want to bring out is that this policy specifically applies to harassment. And the cited IUC policy applies to misconduct. So I would expect that perhaps you want to reword the title of this proposal to misconduct as opposed to harassment, unless you specifically are looking at harassment. So there appears to be a bit of a disconnect there. And secondly, I want to reiterate what the others have said, that there does not seem to be due process in this procedure. It doesn't appear that the accused can face the accuser and get a clear understanding of what the context of the action was that caused the harassment to be charged or misconduct to be charged. Thank you.
Thank you, Mr. Darby. Ms. Taylor.
Yes, thank you. I just want to respond and thank our speakers for coming up and bringing up their concerns about the policy. And I want to share that, in my view, I feel that this policy is necessary in the environment that we are currently in. And we have expectations of appropriate behavior in the workplace and have every right to expect that and to put it into policy. And I believe that there is plenty of discussion on this, and we're bringing back we haven't decided on the language yet. I will say, in answer to Mr. Darby's about the misconduct, it does say in our policy at the very beginning that we are focusing strictly on harassment, and this board has made, since the exposure of some of the incidences that have occurred in public, we take that very seriously, and we do not want this board or the reputation of CalPERS tainted by something like sexual harassment and discrimination. And I think it's really important that we take a stand and show that we are not going to tolerate that. And I feel that that is that important, not to disregard anybody's due process. And I think that, again, we have discussed that we are going to rework some of this language, and we can come back again if we need to. But again, I think it's very important that we show that we are standing up for against sexual harassment and discrimination. Thank you.
Thank you, Ms. Taylor. We do still have one more member of the public who wishes to speak. There are 2 board members who requested to speak. Would you like to wait until after the public comment, or would you like to speak first?
No, I just want
Wait, I'll
speak first.
Okay, thank you. Ms. Brown.
Based on all the comments we've heard, and I think it's going to be a lot of changes to the policy, I think it needs to come back to board governance, not just back to the full board. Thank you.
Thank you. Mr. Juarez, would you like to wait?
Yeah,
or
if
would
I
you like
could, just real quick.
Okay, go ahead.
Just asked Mr. Jacobs, we really haven't proposed any changes with regard to what was raised in terms of due process, and I'm wondering what your reaction is to the points being made by the public speakers relative to the lack of apparent due process in the document. Do you agree with that, or do you think that it's necessary, or are we likely to see any changes with regard to that?
Due process is absolutely important and necessary. There are due process protections in here. For example, at the bottom of page 2, there's an opportunity to respond to the investigator's findings, and there's a process that's laid out there for doing that. There are other due process aspects in here. So there are some that already exist. The question of what is the appropriate due process is always a fact-specific determination, and it depends largely on what it is, what the sanction is that you may be talking about. So, for example, when we're talking about the criminal law and taking away somebody's liberty, that's where you get the utmost in due process. When you're talking about some of the potential sanctions here that are less significant, the due process that is required is less. And so I would say there is definitely due process already in here that complies with the required due process. If board members are inclined to add some, that I'm agnostic on this.
Yeah.
I'm fine.
I may have missed it. Just the one that I'm thinking of is just the right of appeal. Is there any possibility that a person who's so accused and who then has a sanction levied against him could come and say to the full board, say, you know, I think this is truly unjust and I want to appeal it to the full board?
Well, let me look at that again. The section D on page 3 says that the general counsel with the review panel will recommend an appropriate sanction, and then board action, the board takes it up. So it's not an automatic determination of a sanction by either the general counsel or the review panel or the combination thereof. It's just a forwarding to the board of the finding, and then it's for the board. So I think that may encompass what you're talking about.
Okay. So the full board will act on the specific recommended sanction that's being proposed. Okay.
Correct.
And I think that's wholly appropriate and gives me greater comfort about the fact that the person so accused has an opportunity at least to make their case, and I assume that would be in public.
Right.
Thank you, Mr. Orris.
Thank you.
Okay, Did you, sorry, for some reason you came on again. Okay. We do have, is there anyone else who wishes to speak from the board or the committee? We do have one last member of the public who wishes to speak. Mr. Perez, if you would come up and identify yourself and your affiliation for the record. You'll have 4 minutes with which to speak.
Good afternoon, Jason Perez, of Corona Police Officers Association. I had planned on not speaking this whole week, but this is kind of a big deal. I think the board and maybe everyone is kind of missing the mark here, except for Ms. Taylor. We do need to protect people, absolutely. And this drawn-out process, does it talk about how we're going to protect the victim against the suspect at all?
That's a good point.
So we need to worry about that. And then another question is the discipline or the sanctions that you guys are recommending. Is that to change a behavior, or are you going to discipline, like spank? Are you changing behaviors, or are you getting mad and disciplining? Because it's always should be changing behavior, right? And with any kind of sexual harassment, there's likely to be a criminal allegation along with it. So going with an outside agency, it's just a no-brainer. I'm kind of surprised that it's this sloppy coming to the table to you guys, but I applaud you all for giving pushback on it. Thank you.
Thank you. Mr. LaFaso.
Thank you, Madam Chair. Just a suggestion and a question for Mr. Jacobs. The suggestion is, I don't know the last time the sexual harassment policy has been circulated, but perhaps circulating that to the board members might make sense. Apropos to that, Mr. Jacobs, I'm wondering if you can clarify, does that policy contain proscriptions against retaliation against anyone who makes an accusation against anyone to whom the policy is subject?
Yes.
Thank you.
I would also, in answer to your first comment, although it wasn't a question, the policy was circulated late last year, and all members of the board signed it and returned it.
And we're also obligated to undergo training. I believe it's every other year, sexual harassment training.
Yes.
And that, I believe all board members are in compliance with that as well. But it might make sense, I take Mr. Perez's point that it might make sense that, some language to the extent of during an investigation, the alleged harasser will not communicate or in any way contact the person making the allegations, or I don't know, some language to that effect.
Yeah. It's hard to draft language that's going to apply to every situation.
Yeah.
But let me give that some thought.
Okay.
And when I bring it back, we'll see if we can't address that in some fashion.
Thank you very much. We do have a couple more questions. Ms. Taylor.
Sure. So 2 things. I think that you just brought up, I think that can be brought up in the investigatory hearing. I don't know that we need to state it directly in our policy. I think based on the circumstance of each person, we're whoever does the initial investigation can request that, hey, we need you to not contact this person. But then my other concern is, if it comes to the full board for final dispensation, what about the victim? And how embarrassing is that for the victim, is my concern. I get that we want to have it in public. I get we want to have due process. I just want to make sure the victim has been protected. I don't know how we do that.
I think with any criminal or civil action, those types of things require a public process. I don't know. We could think, I don't know what else.
A lot of this requires on judgment as you go along, and I think maybe a statement about proceeding with the utmost sensitivity to the complainant, something of that nature to underscore the importance of this concern.
Sure.
Yeah.
I think that might work. Yeah.
Okay.
Okay.
Thank you. Mr. Fechner.
Thank you, Madam Chair. As long as you're going to go back and go through this, Matt, and come up with other language, I do also want to throw out the caveat that if it's a frivolous suit, the victim now changes. The victim is the person that was then reported on. And I think we need to be mindful of that as well. That, as we're talking about protecting which
Absolutely.
individual,
Yeah.
we have to look at the other side. If it's frivolous, then that victim, who could very well be harmed as well because of a frivolous action.
Yeah.
Mr. Gillihan.
Thank you, Madam Chair. I just, some of us deal with these things on a fairly regular basis, and so and perhaps I could shed some light on this. And one of the concerns was if somebody's accused of something, protecting the accuser. That's sort of a standard approach when and we all have an obligation, by the way, to protect anybody that's a victim of sexual harassment or discrimination or any other workplace behavior that's not acceptable. But it's generally part of the process that when an accusation's made and the person that's accused is noticed that an accusation's been made against them and there's going to be some sort of a process to investigate that, they're always admonished on the front end about anything appearing to be retaliation and that there's a zero tolerance policy for retaliation in the state of California. So if it's done properly, that's very effective because anything that appears to be retaliation can be acted on very swiftly and very definitively.
Thank you for that. Okay, I see no further requests to speak, so I think you have your direction, and that actually brings us to, so we're not doing agenda item 7A today, is that right? So agenda item 7B is a summary of committee direction.
Right. And I think it's pretty clear that I will go back and review the transcript and collect all the comments and reflect them as best I can, and we'll bring it back next month to the full board for further review.
Okay, thank you very. Yeah, including the insurance question.
Yes.
Yes. He's going to review the transcript, and so, but all of the comments with respect to the policy that have been made, you will reflect in some fashion or respond to in some fashion.
Or explain why.
Or explain why it cannot be. Okay, terrific. That brings us to agenda item 7C, public comment. I have no requests before me. Are there any members of the public who wish to speak at this time? Okay, that brings us to the end of the agenda. We are adjourned. Thank you.
Thanks.